Good morning, everyone, and welcome to today's webinar, Development and Construction in a Changing Landscape, Getting On With It in 2020. Before we get started, I'd like to go over a few things so that you know how to participate in today's event. You'll have the opportunity to submit text questions to today's presenters by typing your questions in the question section of the control panel on your screen. You may send us your questions at any time during the presentations. We'll collate those and then answer them all in the Q&A session at the end of today's presentation. I'd like to now introduce you to our presenters today. Dennis Loether, partner in our planning team at Bartier Perry, Gilbert de Chalain, town planner from HDC Planning, and me, Sharon Levy, partner in the Bartier Perry building and construction team. I'll hand over to Dennis now to kick us off.
Thanks for that, Sharon. Good morning, everybody. And on behalf of all of us here, the planning team at Bartier Perry, we hope you thoroughly enjoy this webinar and you find it useful. Together with Gilbert, we'll be chiming in on various issues as in the event flyer. Before we commence with those matters, we want to start with just a bit of an overview on some of the latest updates and the recent amendments on planning laws arising out of the COVID-19 pandemic. These weren't originally advertised, but we just think the overview of the recent amendments is quite helpful for people to understand, particularly for those who are in the industry. So just some of these amendments, first and foremost, they kicked in on the 25th of March. They're effective as of the 25th of March, and they will be effective for a period of 2 years. That is the prescribed period. Some of the changes, the main changes that we've seen are as follows. First one is the minister's been given additional powers provide direction for the pooling of funds received for different purposes or for different contribution plans, and also has the power to specify a time for contributions to be paid. Now, the aim of this is to accelerate delivery of infrastructure and to enable payment of contributions to be deferred. Next main change, development consents have been extended by 2 years for developments that would have lapsed during the prescribed period. Now, remember, the prescribed period here is this 2-year window from the 25th of March. However, the consents commencing during the period will still operate for 5 years. The aim of this is to help people who are recipients of development consents who have not yet physically commenced their consents and who would have, but for COVID. Relevant to sites that rely on existing use rights during the prescribed period, and existing use is taken to be abandoned if the use ceases for a continuous period of 3 years. Now, for those who've dealt with existing use rights, you would know that previously it was a 12-month period. So there is an extension of that time, which is quite helpful. And given the fact that a number of sites are not being used at the moment, we think this may be of some assistance. The length of time that an appeal can be made by an objector has been extended from 28 days to 56 days. Again, it's during the prescribed period or the 6 months prior to the prescribed period. There are some other amendments, but these are the main amendments that I think you should be aware of. There were concerns raised by other minor parties in state parliament in relation to extending periods relating to the Biodiversity Conservation Act and the Resource Recovery Act, as well as the Native Veg Act. Now, these have not been extended. So they are the main amendments that we've seen arising in the last month or so to the EPA Act. No doubt they'll be of interest to all stakeholders. It'll be interesting to see what other amendments are made in the coming months, and we will provide you with updates. At that point, I'd like to invite Gilbert to provide some comments on some of these amendments as how he sees they affect the industry. Gilbert.
Thanks, Dennis. Look, I'd have to say that I'm really quite encouraged by the amendments that the government has made. In particular, we can see that the government is actually understanding the fact that there is a need to assist development in kickstarting our economy. Now, the simple thing of extending the time for a DA consent to exist is something that I'm sure the development industry is going to welcome. You know, we know that it takes a considerable amount of time to actually prepare an application. A considerable amount of time and effort goes into the assessment of an application. And after that period of time has expired, sometimes we find that obviously the marketplace has changed or the cash flow is not the same as it was before. So being able to preserve your consent for a considerable amount of time additional to what was there before does enable obviously our recipients of those consents to have the time to wait and then actually commence their development when the time is right, obviously. So I think that's an excellent initiative. The extension of deemed refusals to 12 months is also an excellent initiative of the government. And I think that also enables applicants and councils to continue to work collegiately in achieving a consent within a reasonable amount of time without forcing the applicant to actually rush to the court and lodge an appeal just as an insurance measure. Because we know that some of the more difficult development consent applications that we deal with take more than 6 months, even if everybody's working together in actually achieving that outcome. So giving us an additional time to actually lodge our appeals for our deemed refusal is a good thing. I think that they're really good initiatives on behalf of the government. Thank you, Dan.
Yeah, look, I think everyone will agree with that. And whether you are, it doesn't matter which side of the fence you sit on, I think there's a collective acknowledgement that there is a need to give more time for certain things to happen. And that's what's seen through some of these amendments. There will be more amendments, I would imagine, in the coming months. And as soon as we hear of them, naturally, we'll provide details of that to everyone. So that's the overview of recent amendments to the EPA Act that we wanted to discuss with you. There will be an opportunity for questions at the end, as Sharon indicated in the intro, but for now we'll move on to the next topic in this morning's webinar, and this relates to planning agreements and particularly developer contributions. I'm sure that most of you are very much familiar with what planning agreements are. We know that they're a tool that are available to developers with the aim of improving flexibility and delivering those positive public benefits. Their take-up has been significant. There are a number of planning agreements in place, but they can also be the source of conjecture. As a general comment, what I would say is caution is required, as when they're not executed properly, they can add cost to projects unnecessarily. And it's a balancing act. It's between project delivery, we're talking about delivering public benefit, and doing so without increasing the cost of development. As is often the case, the costs associated with these agreements and developer contributions are passed on to purchasers. This is a real hot topic, and I'll get to some of the initiatives that the state government is looking at the moment to try and assist with that. So it's not simply a case of delivering a monetary contribution. There are different ways of delivering a public positive benefit through planning agreements. Just to recap, for those who are not familiar with them, the agreement may provide for dedication of land free of costs, the payment of a monetary contribution, or the provision of any other material public benefit, or a combination of them, and it's all towards a public purpose. As it's often the case, well, what is a public purpose? The Act provides, and it's without limitation, that it could be public amenities or public services. It could be the provision of affordable housing, and this is an often used example. Transport or other infrastructure relating to land, just to name a few. So these are some of the examples we have of what is a public purpose. Now, one important consideration is whether or not the agreement excludes, either wholly or in part, the application of Section 711 contributions. And this is a real issue. It's always been raised by my developer clients as to whether or not they can be in lieu of 711 contributions. So you need to be familiar with the fact that they may not operate in lieu of Section 711 contributions. We will talk about this a little bit further on, but it's important to understand that it may well be that through your consent, there are payments that are required pursuant to a VPA, but also the payment of Section 711 contributions. So it's a carefully considered negotiation. Just one note as well, and I have been asked this question in the past, whether or not the entering into of a planning agreement imposes an obligation on the planning authority to grant development consent, and the answer is no. I wanted to touch on a recent decision. It's Bianey and Cumberland Council. It's an interesting decision because it deals with both Section 711 contributions and terms of a VPA. Just a bit of context. So the background to this was there was a development application lodged by the applicant with council for a 12-storey mixed-use development. The matter proceeded to the Land and Environment Court. There was a conciliation conference that took place, and ultimately development consent was granted by the court. Now, the conditions of the consent were interesting because they required the construction of a public road, and it was over land to be dedicated as a laneway. It also provided for the payment of a monetary contribution pursuant to Section 711. already touched on Section 711 contributions, and I'm sure you're familiar with what that means. The land in question the land dedication formed part of a VPA, and it also accompanied a planning proposal to amend the local LEP, so the local environmental plan. Now, Section 711 allows the council to accept the provision of a material public benefit in part or full satisfaction of a condition imposed for the payment of the contributions. Here, the issue was that there was no discount given on the monetary contribution for the cost of the works to construct the laneway to the standard of a public road. And the laneway formed part of a network which is identified by council as being of strategic importance. It formed part of a local placemaking strategy. The parties agreed that the works to construct the laneway to the standard of a public road were a material public benefit. So we had no issue here as to whether or not you could satisfy the material public benefit requirement. The contribution was calculated from Council Section 94 plan, so I refer to it as Section 94 plan, a lot of us still do. And that plan contained a clause which allowed a reduction of the contributions if benefits provided under a planning agreement, and this included works, were considered to be of a material public benefit. So consistent with that clause in the contributions plan, but after the matter had commenced, the applicant submitted a formal offer to council to enter into a VPA, and this was to deliver the works associated with the construction of the laneway. In the court proceedings, the applicant sought to modify the consent pursuant to Section 4.55 of the Act, and specifically what they challenged was the quantum of those monetary contributions that were payable. The challenge was on the basis that it should be reduced to reflect the costs associated with the construction of the public road. And the applicant relied on the broad power of Section 4.55 of the EPA Act and the power of the court to disallow or amend a condition imposed under Section 711. That power is contained in Section 7.13. The council's position was there was no power for the court to permit such a reduction, not surprisingly, and it relied on previous authorities. Council argued that any unreasonableness in the condition arose from the burden of constructing the road as opposed to the application of the contributions plan. And as a result, it fell outside the scope of Section 7.13. So the issues that the court had to consider was one, whether it had the power to vary the contributions. If it did, was it appropriate to do so, given the circumstances? And how should the contribution be calculated? The court upheld the modification application, so it granted that modification application, and it reduced the contributions payable. And some of the key findings are relevant. First of all, as a result of the failure to use that mechanism in the clause in the council's contribution plan, which would accommodate works that the parties agreed to provide a material public benefit, it held that the contribution payable was unreasonable. Again, the unreasonableness doesn't arise from the economic burden of constructing the laneway, but instead arises from the way that the contributions plan had been applied. So in finding so, the court held that Section 7.13 is engaged and there is a power to disallow or amend the condition requiring the payment of the contribution. The court also held that there's a power to amend the contribution as a result of its broader powers in Section 4.55. And in exercising that power, the court held that discretion should be exercised in a manner that is consistent with Section 711 and the clause in the council's contribution plan. So it wasn't an open slather in terms of what you could do. You have to exercise caution when doing so. Importantly, in exercising that power, the court was required to take into account the draft VPA. It's an important point because the VPA here placed obligations on the developer as well. Now, the consequence of the unreasonableness in applying the contributions plan without utilising that mechanism within it is that the applicant had the economic burden of providing the material public benefit as well as paying the undiscounted monetary contribution. Court held that it was therefore appropriate to reduce the monetary contribution. It also noted that whilst exercise of the power under Section 4.55 was available to apply the contributions plan, a strict application of that plan would require a condition to be imposed requiring the entry into the draft VPA. And that's an important point because the exercise of the power pursuant to Section 7.13 to reduce the monetary contributions was held to be a more appropriate course, as there's no power for the LEC to compel the council to enter into a VPA, remembering that the VPA is voluntary. So finally, there was a question in terms of how you calculate the contributions. The condition requiring payment of the contribution was reduced, and the court looked at a formula for doing so based on the difference in the cost between the construction of the appropriate class of driveway and the construction of the public road. it was an interesting decision. I suggest you have a read of it when you have an opportunity. It does shed some light on some of the issues confronted when dealing with Section 711 contributions, and in particular the interaction with VPAs. Remember, VPAs are voluntary by nature. There is no requirement they be in lieu of payment of other contributions, but here we had a contributions plan which had a specific clause which acknowledged the possibility of a reduction. Before I hand over to Gilbert some of his thoughts on contributions plans, I also wanted to just touch on what lies ahead for contributions. Now, we've seen plenty of discussion in recent times about how they are hindering the delivery of much needed housing stock. On the flip side, we see the argument from councils and consent authorities alike that they're much needed because it's an essential element in delivering that infrastructure. It has generated a lot of debate, and therefore it's no surprise that on the 15th of April, the Minister for Planning asked the New South Wales Productivity Commission to review and report on the infrastructure contribution system by the end of 2020. So the developer contributions and levies will be reviewed, and this is in an attempt to boost our housing supply and local infrastructure. I read this morning in relation to what is the predicted numbers of new housing stock that we'll see come online as of next year, and therefore this is quite, the timing of it's quite appropriate. A primary reason for the review as well is the fact that we need a more transparent and certain contribution system. This is often raised as a real concern. We need more transparency in the system. Some of the proposed amendments include requiring council to publish how much they collect in developer levies and to identify where the money is being spent. It also plans to tighten the ability of councils to use VPAs, ensure they're clearly tied to infrastructure. Now, the use of VPAs is often cited by our applicant clients in terms of a long-standing concern: where's it going to, what's it for? One of the other things that the Commissioner will consider is caps on council rates. This always generates heated debate. The capping of council rates at 2.6% has limited what councils can generate in revenue to fund infrastructure, and therefore it makes them more reliant on developer levies. So the argument's put forward that if you were to increase the cap, it may be that the councils will be less reliant on developer levies. There's also a series of more immediate changes which were released in April for public comment. Some of the reform package can be broken down into key areas. One key area is draft practice notes to assist parties when drafting BPAs under Section 7.4 of the EPA Act, and a draft direction requiring councils to consider when negotiating or preparing BPAs. I think this is a good initiative. There's a discussion paper which explores the options to simplify and shorten the process for reviewing contributions plans, which are reviewed independently by IPART. The discussion paper also looks at the criteria to help determine whether maximum fixed rate contribution levies, up to 1% of the cost of carrying out development, should be increased in respect of particular land in specific local government areas. Again, the more site-specific or area-specific approach. And there's new guidelines which will relate to special infrastructure contributions or SIC payments. For instance, if a development feasibility is to be impacted, the SIC may be adjusted to reduce the scope of the infrastructure to align with the revenue forecast to be received by the SIC charge. So you then cap the charge or consider percentage base cost recovery target. There's a policy paper as well which sets out proposed amendments to the EPA regulations. The changes aim to improve transparency and accountability measures to require council to publish how much they've collected in developer levies and where they've been spent. So I think it's a really important point in terms of having accountability and transparency. I think some of these initiatives will be welcomed by all. Gilbert, I'd like to hand over to you with some of your comments on some of those initiatives and also contributions generally.
Thank you, Dennis. That was very informative. Fascinated by the case that you just spoke about. I will actually have a read of that myself, you know. Look, developer contributions, planning agreements is something that we as planners representing developers struggle with. I know that our applicant clients struggle with the idea of contributions and particularly voluntary planning agreements. And as we've spoken previously, Dennis, I struggle with the whole concept. I can see the absolute positive nature of a voluntary planning agreement. It's good government policy to be able to have a system in place that enables a applicant to recognise that that particular development might put an additional burden on infrastructure needs of a particular locality, and to be able to contribute positively to that infrastructure provision in return for allowing the development to proceed. I think that is good policy. It enables development to proceed. But other times I do have a difficult time reconciling the notion or the idea that a developer is then required in some occasions to actually pay for development rights almost, where there is some councils that have incentive FSR provisions within their local government plan, within their local environment plan, that enables a developer to pay additional to enable them to access further development rights. Now, I struggle with that idea because in some respects, I can see where the council is coming from, in that additional floor space, additional development intensity means there's a need for additional infrastructure. But then if I look at my developer client's position, they would probably argue that, or they do argue that, if a certain development capability of a particular site is such, well then they should be able to access that as such, not have to contribute additional funds. So I can see that the toing and froing between this particular issue. It's a delicate balance, I think. You know, if we look at, and as you're saying on your slide here, if we look at the aims of a voluntary planning agreement, I think if we stay within that aim, the objective of that particular provision within the Act, I think that we do well. I think the waters get muddied when we start looking at other ways to actually raise funding through development, for argument's sake. I think we need to change the argument. It's not actually raising dollars through development, it's actually a system that enables development to ensure that infrastructure is there to cater for their additional development on the site. I'm also very encouraged by the proposed review of infrastructure contributions. Having IPART or the Productivity Commission re-look at the way that Section 94 is being, I'm still using the old term, Section 94 being used to raise funds is a welcome initiative. If we cast our mind back to the sort of 2007-2008 period, I remember IPART looking at developer contributions back then as well, and which actually resulted in the capping of developer contributions. I think that, again, it's really important for local authorities to be able to recognise the additional burden that new development will have on infrastructure. I think it's a good system to enable the council to actually think about the needs of the community, the future needs of the community, and come up with a plan that enables the delivery of that infrastructure. However, what we need to be really careful of is, well, what are the essential needs of the community? We don't want to find ourselves where we've got gold-plated Section 94 plans that would, you know, astronomically increase the cost of producing lots and producing housing, much needed housing, to the point where, if we look back in time, to the point where there were, you know, developer contributions of about $80,000 in some examples required to produce a lot. Now that actually pushes the feasibility out of the reach of the marketplace that you're trying to deliver the housing to. So again, there's a delicate balance to be had between the level of contribution. We need to properly consider what is an essential need for the community, and then come up with a reasonable contributions plan that is sensitive to the economic feasibility of producing lots for housing. So, I mean, from what we've talked about just then, Dennis, again, some encouraging things to see, and I guess for us as a planning firm that works for developers, we keep a close eye on this issue of developer contributions and VPAs. Thank you.
Yeah, and they're all valid points, and I think it is getting the mix right, getting the balance right. And I mean, what you mentioned there in terms of some of the contributions that are payable by developers, if we review, for example, rate pegging, that may well have an impact on that. It may well have a positive impact in that there's less reliance on those contributions going forward. But it's good to see that it's being considered, and no doubt we'll have more news when the Productivity Commission releases its findings. So that was what we wanted to cover on planning agreements and developer contributions. At that point, we just wanted to move forward with the next topic, and this is something which has come up for a number of my clients recently with questions in relation to modifying consents mid-construction, and just asking what are some of the considerations. Now, we're in a changing marketplace, it is a unique time. It's not uncommon for applicants to seek to amend their applications mid-construction. It could be increasing building envelope or density for residential developments. It could be internal reconfiguration. It could be changing the unit mix. Now, there's several issues which arise for consideration, and I think it's important that you be aware of them. What is the best path to follow? What type of application should you lodge? And it's not always a straightforward proposition. In some circumstances, it's preferable to lodge a new development application for additional floor space. In other instances, it may be preferable to modify an existing consent pursuant to section 4.55 of the Act. So just looking at some of the options, in terms of modification applications, it's possible to lodge a modification application to modify the consent you already have obtained. You do need to satisfy substantially the same test, and this is a crucial consideration. Will the development as modified remain substantially the same development which was originally granted? Will, for example, adding an additional story to an approved residential development render that development substantially the same? These are key considerations which do come up. In terms of timing, it's important to factor in that works may need to cease if it means continuing within original consent will result in variations if the modification application is ultimately approved. So you really need to dig deep into looking at what you have approved and what it is that you're seeking to modify. It does open the door to modify conditions of consent, including, for example, 7-11 contributions, as they're likely to have gone up since the issuing of the consent. If works have already been completed, and this is an important point, and I had a recent matter where this was an issue, and those works were beyond the scope of the existing consent, council is likely to require a building information certificate to be obtained. This is to certify the work's already done. Now, this can be imposed through a condition of consent in any subsequent or modified approval. One other point, if your matter does end up in the LEC, it's important to note that some of the cost provisions that apply to amending an application in respect of modification applications are not generally applicable. So that's a bit of a rundown on some of the key considerations if you're looking to modify your consent by way of a modification application, section 4.55. Often, it may be appropriate to lodge a fresh development application. This could be to add to an existing consent, for example, for an additional floor, or to supersede the old consent altogether. You don't have the substantially the same test, which is one key difference. Works can continue in accordance with the original consent if, for example, the original consent granted approval for X number of stories, they remain unchanged and you're simply adding another story on top. That's one example that I had recently. So you need to carefully think about what are the options available to you and what is the best way to go. In terms of modification applications, it is important to understand that there are different types of mods, and it's always important to get the application right. Your 4.551s, which are just your real minor amendments, your 4.551As, where there's minimal environmental impact. What does that mean? Your 4.552s, which are the modifications, and 4.56, which is a modification of a consent granted by the LEC, where you can go straight to court. One other point which came up recently, which I thought was of interest, effective modifications in terms of lapsing of consents. An approval to an application to modify a consent doesn't extend the lapsing date on a consent, so that's really important. You don't get the benefit of a fresh period. I say that in the context of disregarded the most recent amendments arising out of the COVID-19 pandemic. So that aside, if you obtain an approval to modify your consent, it doesn't extend the lapsing date. So there are different paths to travel when it comes to modifying your consent midstream. There are different considerations. I'll pass over to Gilbert there for some comments on some of these issues. I'm sure some of your developer clients have asked questions of you guys in relation to what should they do when they want to modify their consent midstream.
Yeah, thank you, Dennis. It's a tricky one, particularly picking up on your points that you're making there. You need to consider each application on its own merits. There's not one answer that fits all, depending on where you're at. I tend to lean towards seeking a modification of a consent that we've achieved before lodging a new DA to amend it. That's what I tend to lean towards. Obviously, it depends on the circumstance. You know, clearly, I need to be able to argue that the modification is still substantially the same. But like I was saying to you, I favour modifying a consent rather than lodging a fresh one. But I do see from what you were talking about and some of my other experiences as to why you would need to lodge a new DA. So the comment that I would make though is that it seems to be becoming more and more difficult, and this is my own experience, in being able to convince the authority that I am actually doing a modification. I seem to think, this is my experience, I seem to think that the authority tends to actually wish to see new DAs come in as opposed to a modification. That's my experience. I guess what would be nice to be able to provide is some further guidance towards the authority and to the practitioners, of course, by way of maybe a practice note or things like that, to actually confirm what actually is a modification and what is actually required for a new DA. Maybe something like that would assist. But let's face it, development the timeline extends. So there's going to be a need to be able to do these sorts of modifications as time goes on. That is the nature of our business. So my comment would be, let's actually make it easy and make it right and correct for all. That's the way that I feel about that. Yeah. Thank you.
Okay, so that were some of our comments on modifying consents mid-construction. I hope you take some of those key points on board. And if you have any questions, of course, feel free to send them through. Now I want to move on to the next topic, which is issues with the certification regime and in particular obtaining occupation certificates. Now, this is a really interesting one, and I often laugh to myself about some of these new amendments because it took so long for them to come into force. We had modifications which were made, amendments made to the EPA Act back in March of 2018, except for Part 6. And those Part 6 amendments made changes to the certification regime. They were delayed, and this was to allow, we're told it was to allow the sector to adjust to the other regulatory changes. Finally, the new Part 6 amendments took effect from 1 December 2019, and I just wanted to touch on some of these in case people aren't familiar with them. In particular, those pertaining to interim occupation certificates. So the terms interim and final in terms of occupation certificates no longer exist. Instead, we've got a regime whereby you could have an occupation certificate issued for either part of or a whole building, including parts of a partially completed new building. The occupation certificate will continue to certify that the building or the part is safe to occupy, including parts of partially completed buildings, but the notion of interim and final is no longer there. Now, one key change is aimed at ensuring that a building is not occupied indefinitely under a partial OC, which may be issued for part of a partially completed building. The regulations now require that a further OC for the whole building be obtained within 5 years of the partial OC being issued. I think this is a really important amendment. It does give some finality. It does give you an end date. Otherwise, you could have a situation where an interim OC, or what we had previously, whereby an interim OC was issued with no requirement for the final OC. The provisions that allow the occupation and use of a property without an OC where it had been occupied for over 12 months have also been removed. These OC provisions, the amended provisions, only apply to consents granted from 1 December 2019. So any consents which were approved prior to this date are subject to Part 4A of the Act. Now, the effect of this change is really important. Developers and builders alike will need to revise their development programs and any contractual, financial, or insurance implications may have for their projects. So it's important you are aware of those changes. Some of the other changes which came in as part of the amendments which took effect in December last year relate to subdivision work certificates. A CC can no longer be used to certify subdivision work. After the commencement of the changes to Part 6, a subdivision work certificate will be required to be issued by the certifier prior to any subdivision work occurring. Subdivision work certificate it's not to be confused with the subdivision certificate. One's obtained prior to subdivision works. The latter is obtained after construction to authorise the registration of the plan of subdivision. So you do have the two certificates. Subdivision works means any physical activity authorised to be carried out in connection with the subdivision under the conditions of a consent for the subdivision of land. As I noted already, these provisions only apply to development consents granted from 1 December 2019. So it's really important councils will need to make sure that the conditions of their consent includes a process for obtaining subdivision work certificates. And for builders and developers alike, the importance of reviewing and understanding those conditions has never been more important. One other amendment which I wanted to touch on was the need for greater consistency with development consents. As of 1 December, the court has power to declare construction, subdivision works, subdivision or compliance certificate invalid where those plans are not consistent with the development consent. So the test for consistency is now stricter as compared to the previous regime. Don't know how much litigation we'll see in relation to this, but I'm sure at some stage someone will be eager to test what is consistent, what is not consistent and what is meant by that phrase. Finally, there's new mandatory orders for non-compliance. Principal certifiers can no longer issue a notice of intention to give an order, but council still retains this power. If a PCA becomes aware of a non-compliance, it has to issue a written directions notice, and this has to occur within 2 business days, and then direct the person responsible for the non-compliance to take the specific action to prevent or remedy the non-compliance. So there are some further orders. I suggest if you're not familiar with some of those provisions, you may have forgotten about them because they were initially mooted back in 2018, and some of those provisions, or the Part 6 provisions now are in force. Have a read of the Act, and if you have any questions, always feel free to contact us here at Bartier Perry to assist you with it. But they are the key amendments which kicked in as of December 2019 in relation to Part 6. That concludes the first part of our presentation, dealing with some of the planning changes and contributions. I now will hand over to Sharon, who will continue with the webinar. So over to you, Sharon.
Thank you, Dennis and Gilbert. So now that we've spoken about the planning side of things, I'll move on to the building and construction phase. So construction was deemed an essential service fairly early on in this pandemic. Everyone thought and hoped it might just be business as usual for the building and construction industry. We were quick to learn, though, that a lot changed in terms of safety and the way things were carried out, such as the need for hand washing and temperature taking on site, wiping down tools and cleaning, as well as social distancing measures. All of this, unfortunately, has meant that builders are losing a lot of time on their projects, and for many, project milestones may not be being met. In today's climate, there are some projects that are going to fail. This can be for a variety of reasons, and it's important for both developers and builders to be able to spot the warning signs early. So first of all, developers, they need to look for signs of changes in personnel and possibly more junior staff being employed by the contractor. A builder may experience cash flow issues in the current economy for a variety of reasons, including fewer projects getting off the ground or having a delayed start. While the builder navigates through these cash flow issues, it might be that they need to employ more junior staff to replace its experienced staff as a way to reduce some labour costs. This alone may not be a cause for alarm. However, less experienced staff could ultimately mean a lower quality build. Progress may also slow when subcontractor payments are delayed, which means a subcontractor may down tools, and delivery of materials may slow as credit from suppliers dry up. This again will be a function of cash flow issues and again may affect milestone dates. Prudent developers should walk the site regularly and listen to the subcontractors. They will generally be happy to grumble about any issues that they might be having and let you know what's going on and whether you should be concerned. It's important also to make sure that developers are getting evidence of payment to subcontractors and to suppliers. For those contracts that fall under the Security of Payment Act, this could be in the form of a supporting statement required to be served at the same time as a payment claim. So if problems do arise, it really is important to talk to the builder early just to see if the issue can be resolved. Developers should issue relevant notices under the contract in an attempt to have the builder remedy the problem. Notices can also sometimes be a precondition to termination, so it's important that those notices are getting issued in a timely manner. If the contract does need to be terminated, it is really important to follow the procedure in the contract. In our team, we see a lot of developers come unstuck at this point in terms of following the correct procedure of termination, and that often can mean a wrongful termination claim against brought by the builder down the track. So once terminated, make sure you secure the site by locking out the builder and their subcontractors and immediately insure the project. Check if there's any security under the contract that you might be entitled to, for example, an enforceable bank guarantee. Check also that you have any progressive certification and current certificates from subcontractors. It might be difficult to obtain these at a later point, and generally the new contractors who come on site won't certify the work of others. You also need to commission a dilapidation report before you get any new contractors on site as a record of any existing damage and defects to that point in time, and also establish a cost to complete analysis. These reports will be invaluable down the track if you are going to make any claim against the builder in the future. So from a builder's perspective, what can be done if you're facing difficulties or an inability to complete the project? First up, it's really important to be proactive. This is a really important first step. Builders experiencing cash flow difficulties really should try to negotiate with their creditors and subcontractors. This might mean extending your payment terms or otherwise reaching some kind of agreement which will avoid or delay at least enforcement action down the track. Also approach the developer and discuss the issues with the developer and try to reach a resolution. Depending on your relationship with the developer, this could include an advanced payment to allow you to pay for suppliers and so forth, or otherwise varying the contract to resequence your milestones, or even having milestones split to assist in the builder's cash flow. Builders should also take advantage of the new extended days for construction allowed under the new COVID-19 legislation changes. So these changes allow construction sites to operate on weekends and public holidays during the same hours that they would otherwise operate on the weekdays. By extending these hours, it's a way for builders to make up some of that lost time that we spoke about earlier. This, though, will need to be balanced with labour costs, which would necessarily increase by working these extended hours. Builders also need to make sure they're lodging extension of time claims allowed under the contract as much as they can, and this will help ease stress on your milestone deadlines. Be aware of liquidated damages, entitlements under the contract for developers in circumstances where the project may not finish on time, and try to seek to limit that entitlement as much as you can. Finally, ensure the provisions of the Security of Payment Act are being used to your benefit, including lodging payment claims as often as you can as a way to try and maintain your cash flow. It's really important that you position yourself with the competition. In this environment, COVID-19 has generated a halt in the number of new projects for builders, and this has necessarily meant more competition. It's important, though, that builders avoid the temptation of lowering costs just to win a contract. It's only going to lead to cash flow and other difficulties down the track. Developers also need to be aware of cost cutting and fierce competition among the builders to get the contract. They need to remember that cheapest isn't always the best option. Cost cutting could result in contract estimates being far exceeded and budgets completely blowing out. It could also mean a lower quality material being used and a higher rate of defects in the work. That are problems both for the builder and for the developer. So we always recommend trying to resolve the dispute before resorting to debt recovery or litigation, especially now when times are tough for everybody. It's really important that both parties follow the alternate dispute resolution or other conflict clauses within the contract. Sometimes though, we understand that disputes are unavoidable and just can't be resolved, and it might be that proceedings need to be commenced to enforce rights under a contract. Firstly, before you do anything, you really do need to consider who is the correct party to sue. As strange as it seems, this is often not as easy as it sounds, particularly when there are a number of entities in the one group. The next thing to consider is how to proceed. In this COVID-19 environment, litigation and debt recovery does look a little bit different. For example, there have been recent changes to the statutory demand regulations as a result of COVID-19. For example, a debt now must be $20,000 or more to issue a statutory demand, as opposed to the old $2,000 that it was under the previous regulations. Also, on top of those changes, a debtor now has 6 months to comply with a statutory demand, as opposed to 21 days, which it was previously. At this stage, these changes are in place until the 22nd of September, and the changes might mean that commencing proceedings are a better option as opposed to issuing a statutory demand. One of the most cost-effective ways to recover a debt as a first step when an argument has arisen and an agreement just can't be reached is to issue a letter of demand. To this end, I'll give a shameless plug to our online service. It's the letter of demand that you can just jump onto our website and complete, and for $55 we'll issue a letter of demand. And that often, as found by a number of our clients, is actually enough to either resolve the dispute and get the debt paid, or otherwise get the parties talking so they can enter into some other arrangement such that proceedings or other litigation enforcement action may not be required. So that's all from me for now. We're going to now be answering the questions that have been submitted and have come through during today's presentation. As a reminder, you can still submit questions through the question section in your attendee control panel. So we will answer those now as they come through. Dennis, there's one here for you that has come in. Why should developers pay monetary amounts under a VPA in addition to Section 711 contributions?
Yeah, it's a good question. I mean, obviously, as we mentioned in the presentation, it's a difficult negotiation, and I can see both sides of the argument. There's obviously a need to deliver infrastructure and to deliver facilities and public benefit. And the question is often asked, well, shouldn't the contributions cover this? Unfortunately, they don't. And that's why you have a situation where you have VPA payments. So I think it's unfortunate that we have this regime in some respects, but it's a necessary evil. I suppose one thing that we'd like to see is, and they are voluntary, by the way, it's important to note they are voluntary payments, but it's important that there be transparency in the process. And I think the state government's achieved that through the legislation that we have, but it's not an easy negotiation. So in a perfect world, we wouldn't have to, but unfortunately we have to.
Thanks, Dennis. One question that's come through for me: how easy is it for a builder to terminate a contract rather than a developer? So generally speaking, for both a developer and a builder, there needs to be a substantial breach in a contract, and obviously this will always depend on the contract terms itself, but speaking generally, there'll need to be a substantial breach, and some contracts will specify what a substantial breach is. Otherwise, it needs to be determined and open for interpretation. But for example, non-payment, often it's required, well, the contract might require that the affected party issue a notice as to the breach, and in that event, they're given a certain amount of time to comply, and if the breach is not rectified, then that's an avenue for termination. Generally speaking, most contracts, or some contracts might have, as far as the developer is concerned, an option to terminate for convenience. This often isn't an option for a builder, but it's certainly something to look at when you're negotiating the terms of the contract before signing. In this environment also, there's something called a force majeure clause that some contracts, not all, might include. And that's a term in the contract whereby if something unforeseeable happens or in unforeseeable circumstances, it might be an option to terminate the contract. And arguably, COVID-19 might fall within a force majeure clause, but all of those clauses are very specific to each contract, and the circumstance will need to be reviewed depending on each contract and the wording of that contract. One other question. What do you think about paying contributions via a VPA in return for additional floor space? Gilbert, is this one for you?
I think you touched on this in your presentation, didn't you, Gilbert? Your earlier comments.
Yeah, I did, and as I said in when we were having a chat earlier, I do struggle with it. But maybe I can answer the question by answering the previous question as well that was directed to you, Dennis, about the need to pay for pay a VPA contribution in addition to a Section 94 contribution. I'll answer it this way. I think that it is absolutely appropriate to pay for, and this is scary for me to say this, to pay a VPA as well as Section 94. Because if I look at what VPAs are all about, is actually contributing to something that was not foreseen. It's it's in addition to what was already planned for that particular location. So, for argument's sake, if I, as an applicant or as a developer, can see a ability to exceed the development controls that apply to that particular site and achieve a better outcome, but at the same time will increase intensity and demand on infrastructure, I can see a justified argument in paying my Section 94 for the base and then paying an additional VPA contribution for the addition. Okay, so I can see logic in that. But conversely, going back to the question that was just asked about actually paying for additional floor space, I find that difficult to reconcile sometimes, because what that really translates to is actually a tax on development. So basically, if I develop, I get taxed for it. And it's just a different way of saying it. I do it via VPA. I struggle with that because I think that when we're actually planning at the council level or the state level, we're looking at an area, we're coming up with a suggested or future development pattern, a certain intensity, certain types of land uses, and then we actually plan for that. We provide infrastructure and things like that. But then to be able to say that we know the maximum capacity of a particular area, but then we'll lowball or bring the development standards back and give you a baseline that you can achieve without paying an additional contribution. But then if you want to actually achieve what really is what's intended for this area, you need to pay more. I have a problem with that. I do. That's my comment. Thank you.
Thank you. Thanks, Gilbert. Just one final question. Does the appointment of a liquidator to the builder automatically terminate the building contract? Generally, the appointment of a liquidator will be defined in the contract as an insolvency event and will terminate the contract. So in that event, the developer will be open to engage another builder to come in and take over. So thank you, Dennis and Gilbert, and thank you everyone for attending today's webinar on development and construction in a changing landscape. I hope you found it useful. If you do have any other questions, please reach out to either Gilbert, Dennis, or myself, and our contact details are up on the screen there. Once you leave today's webinar, you'll receive a survey on our presentation, and we would appreciate if you could complete that and provide your feedback. You'll also receive a follow-up email within a day or two with a link to view the recording of today's webinar. So on behalf of Bartier Perry and our presenters, thank you for joining us. Enjoy the rest of your day. Thanks again.
Thank you.
Thank you.